Here, Deputy Governor, Trader, CEO of the Financial Services Commission, Chairperson of the Mauritius Bankers Association, Secretary General of the Mauritius Bankers Association, CEOs, ladies and gentlemen. I'm not going to extend me the speaker, I'm just making a short introduction. And in fact, thinking of banks, last night I thought that I would look for a definition of a bank. So I went on the internet and I found out that, I don't know how many of you bankers do that apparently the origin of the word is that in the old days, it's from Old French and Latin. You used to have traders who had benches, des bancs, and in Latin, banco. And so they had those benches and tables where they used to trade money and exchange notes. And so in Latin, it comes from Latin banco, from French banque, and apparently Germanic banking. And if a trader defaulted, the populace would turn against him, come and rupture his table, and therefore he would become bankrupt because we would have broken his table. So that's how bankrupt also comes from. So I hope this afternoon the Minister of Finance won't break any tables, or those MPs supporting him break the tables in front of them. Juriconsult Chambers has for a long time been associated with banking and financial services. In fact, I'm wearing another hat as Chairperson of the Financial Services Commission. We have the opportunity to work with the Deputy Governor. Today is a technical session. It's not Martin, who Joanne will introduce in a minute, is an empirical positivist speaker who will talk about banking and what's changing in banking recently. And without much ado, I introduce Joanne. Joanne Haig is a partner. Joanne joined us last year. She used to be with Linklaters and then with JP Morgan. And Joanne, if you want to come and introduce the others. Well, of course, what we're going to do this morning.
We're very excited to have you here today to talk about some of the most topical legal issues faced by the world of banking and finance. Juriconsult Chambers is thrilled to organize this session with our partner DLA Piper. As many of you know, Juriconsult forms part of the DLA Piper Africa Group, which is basically an alliance of leading independent law firms across Africa. I'm sure many of you have heard of DLA Piper before. For those who haven't, it is actually the largest law firm in the world, measured by revenue, with over 4,200 lawyers in 30 jurisdictions. And this affiliation gives us an invaluable platform to access and share knowledge of key deals and legal updates, something which is crucial in this day and age to enable us to provide service to our clients to the level and quality that they deserve. So once again, welcome, and I hope you enjoyed today's seminar. Before handing over to our guest of honor, I just wanted to say a few words about the legislative framework for banking and finance in Mauritius. As you all know, there are two main regulatory bodies. So the Bank of Mauritius, on the one hand, that deals with everything that is to do with banking. So banks, non-banking, deposit-taking institution and cash dealers. And they are governed by two main acts, which are Bank of Mauritius Act and Banking Act. And on the other hand, you have the Financial Services Commission, which basically deals with everything that is non-banking financial services. So investment funds, pension schemes, the global business sector, etc. Today's focus will be mainly on the former, that is the banking sector. So we're going to be talking a lot about what's happening in the world of banking and finance, how this is affecting us, what are the key legal developments and implications, and what the future holds. So we thought maybe it would be interesting to just spend a few minutes on the history of banking in Mauritius. How did we get there? We all know what the institutions are, broadly what they're meant to be doing. How did it all start? Mauritius had free banking actually in the 18th century and in the early decades of the 19th century. Banks competed with each other in issuing banknotes until 1849. Capital moved in and out freely of the country, and money was backed by gold and silver. In the 19th century, different commercial banks started functioning as the Bank of Mauritius. The first Bank of Mauritius started its operations in 1813 and soon ceased in 1825. Then you had the second Bank of Mauritius that started, it was originally a British offshore bank, and in 1838 you had the Mauritius Commercial Bank that also operated as a Bank of Mauritius. And as a result of the financial crisis in London in 1848, one of the banks collapsed and the MCB continued until the present time. As for currency, it was enacted by the Board of Commissioners of Currency. That wasn't very popular because, especially in the 1960s, as independent countries started emerging, the issue of sovereignty was key, and that didn't last very long, which led us to the establishment in 1967 to what we now know as the Bank of Mauritius. So the Bank of Mauritius was established. It was modelled on the Bank of England model. It worked well, and the legislation was further enhanced in 1979, in 2004, etc. And in October 2004, the Banking Act 2004 was introduced to further consolidate the laws relating to business and banking and other financial institutions in Mauritius. In parallel, we had obviously the Financial Services Commission, which was established in 2001 to deal with all non-banking activities. So this is very, very briefly where we are today in terms of legislation dealing with banks. And what Martin is going to deal with today is all the key legal and financial updates to do with the banking world, how this is potentially affecting your business, and key issues that you will have to think about in your day-to-day dealings and transactions. So we're very excited to have him here. And I will let Mark introduce our guest of honor. We're very, very honored to have Deputy Governor here.
The Governor apologized at the last minute, and we understand today's budget day, but he's honorably replaced by the Deputy Governor, who most of us know very well, Mr. Gugulai. Mr. Gugulai is an accountant by profession, but he's been at the Bank of Mauritius, I understand, for 30 years, and in 2006 became the Deputy Governor. So, without losing more time, let me introduce Mr. Gugulai.
Chairman of the EMEA, Chief Executive of the EMEA, CEO of the Financial Services Commission, CEO of banks and financial institutions present. Distinguished guests, ladies and gentlemen, very good morning to all of you. Like as Mr. Han mentioned, the Governor should have been here, but last minute we made it, and he asked me to step in. But it's nice to see almost all of the CEOs of banks are present today. I'm pretty sure that back in his office, if he's looking for one of you, he won't see you there. It is a pleasure for me to address you today at this seminar on international banking and finance organized by Juriconsult, International Legal Services, in association with DLA, Piper Africa Group. I understand this is the first time that Juriconsult is holding a seminar on this subject, and I wish to commend Juriconsult for this initiative. I'm sure Mr. Martinez, the distinguished speaker, will provide participants with valuable insights into legal and compliance issues underlying investment linkages between Mauritius and the African continent, as well as compliance with FATCA. This is my first public address since my reappointment as First Deputy Governor in December, although I've been in office since 2006. I can say that this is the right forum to share with you some thoughts on the challenges faced by our banking sector as it gears itself to take advantage of growing opportunities on the African continent. The banking and finance world was in a state of flux after the global financial crisis. A vast global reform program was initiated in the post-crisis era to enhance the resilience of global financial system. Authorities and international standard setters have been working relentlessly to improve the legal and regulatory environment of the financial system, be it at the domestic or international level. Banks and other financial institutions need to be fully conversant with these standards. Africa's ability to sustain economic growth during the global crisis has earned it to be referred as the emerging or rising continent. It is the second largest and second most populous continent of Asia, but also the least economically developed continent. However, innovations and technological advancement in its banking models through the use of mobile and other forms of branchless banking has set the continent to become the new banking destination. The Economic Intelligence Unit forecasts that bank assets in Africa are expected to triple by 2020 and considers Mauritius as a safe country in which to establish a business with a view to branching out into other parts of the region. Our banking sector has outgrown its frontiers. Our banks are now serve both the domestic and global markets, with a large chunk of their banking business with non-residents. Several Mauritian banks have extended their footprints on the African continent, while South African banks have set up shop here in Mauritius. So there are plenty of opportunities for our banking sector to reap the benefits of cross-border banking. But cross-border banking entails new potential sources of risk. These risks call for a greater commitment and adherence to the common rules of the game as embodied in internationally accepted standards and practices. We are all excited about investing and dealing with Africa because, first and foremost, Africa remains an emerging continent with growing markets and rising industries. We must not lose sight, however, of the fact that Africa comprises not less than 56 different countries with different socio-political setup, legal and regulatory systems, as well as other inherent problems such as corruption. Some African countries are also subject to international sanctions and embargo. Banks and other economic operators, for that matter, must be mindful of these hard facts when they embark on business ventures with emerging continent. They must ensure that in their endeavor to make the most of business opportunities, their risks are well managed and mitigated. Let's not forget one essential truth. A bank is a business. It can make mistakes when it decides to invest somewhere. It can fail. Not so long ago, some of our banks suffered losses on account of their investment and dealings in India. In some cases, the losses resulted, among other things, from the lack of proper assessment of the Indian legal and regulatory framework. One of our largest banks has had to sustain significantly high impairment charges as several of its Indian global business exposures become non-performing. It had to make provisions for these non-performing loans, which have had an impact on its balance sheet, although it's not one. At the end of the day, the bank had to close this line of business and ring-fence these exposures by means of significant provisions and active recovery moves. Still, more recently, an African central bank cancelled the license of of one of its banking institutions, as it was no longer in safe and sound condition. It was grossly undercapitalized and facing chronic liquidity challenges. What a fate for an institution that was seen as an iconic bank and a poster child for that country's liberalized financial services in the 1990s. One of our banks, balancing this operation as it had a major stake in that banking institution. In spite of all its efforts to redress the situation, the difficult economic conditions prevailing in the country, coupled with problems internal to the bank, made that it had no other recourse than to cease its banking operations there. Luckily, our bankers are quick to learn their lessons. I can assure that they are taking the necessary steps to prevent such misfortunes from happening again. I can only, therefore, recommend our bankers to exercise caution and conduct proper due diligence before they venture themselves in seemingly profitable projects with their African counterparts. Mr. Anthony, allow me to say a few words about the famous US Bank. A lot has been written and said on this controversial piece of legislation. Several Canadian citizens have even filed a lawsuit against the Canadian government challenging this constitutionality of the agreement the Canadian government struck with the United States. I'm sure that the global community is earnestly awaiting the pronouncement of the federal court in Canada in the matter. Why is there so much confusion about FATCA? Well, simply because FATCA has far-reaching effects. It is a domestic law with international ramifications. It requires foreign financial institutions, among others, to register themselves with the U.S. Inland Revenue Service, to conduct specified due diligence on U.S. citizens and residents, and report specific information on specified accounts held by U.S. citizens and residents to them. If the foreign financial institutions don't comply, they will be subject to withholding on certain types of payments relating to U.S. investments. That definitely sounds and tastes bitter and leaves no room for delay. It comes as no surprise, therefore, that Morrison decided to adhere to the reciprocal model intergovernmental agreement put in place by the U.S. ROIs to facilitate compliance with FATCA. We need to bear in mind the survival of our financial services sector, which needs to maintain its global competitiveness. In December 2013, the governments of the Republic of Mauritius and the United States of America signed a tax information exchange agreement, as well as a Model 1 reciprocal intergovernmental agreement. Mauritius was, in fact, the first country in Africa origin to do so. The conclusion of the Model 1 IGA enables the implementation of the FATCA in Mauritius without the need for major amendments to the existing laws. It is supposed to minimize the compliance burden of Mauritian banks and other financial institutions. Nonetheless, I'm given to understand that compliance with FATCA has been quite onerous, both in terms of financial and human resource investments. The next stage would be compliance with the European FATCA. In October 2014, Mauritius, alongside 50 other jurisdictions, signed the first ever multilateral competent authority agreement to automatically exchange information under the global standard for automatic exchange of tax information. Under this agreement, jurisdictions are required to obtain information from their financial institutions and automatically exchange that information with other jurisdictions on an annual basis. Mauritius has already committed itself to the first information exchange under this agreement. It will in September. In fact, it is common practice for supervisory authorities and regulators around the world to share information on a bilateral basis. Supervisory cooperation and information sharing are fundamental to maintain the safety and soundness of their respective financial system. On the domestic front, the Bank of Mauritius has signed memorandum of understanding with 7 local agencies and institutions which aim at strengthening and facilitating facilitating cooperation between them and 15 foreign counterparts in its quest to promote cross-border cooperation and coordination. Automatic exchange of information is becoming the norm, like it or not. If we wish to become a reputable international financial sector, we need to adhere to international best practices and confirm our position as a jurisdiction of substance. Let me now conclude. Our financial sector has reached its present state of development because of the bold measures taken by the authorities in the 1990s, when Mauritius took the decision to suspend exchange control. Our financial sector has now reached a turning point. I'm confident that tonight our Finance Minister will announce still bolder measures that will allow us to progress on our ambition to become the international financial sector of the world. I now leave the floor to our distinguished speaker who will provide you with a welcome update on the legal and compliance issues in the field of international banking finance and its implication in Mauritius. I wish you a fruitful and insightful seminar.
He's an academic, he's a lawyer, he travels to faraway places like Mongolia, China, all over Africa. He's worked in Europe, lecturing on banking law and financial services. So, Martin, the floor is yours.
Okay, thank you very much. Good morning. Governor Mark, guests, thank you for attending this morning. As was indicated, I represent DLA Piper. DLA Piper, as was mentioned, is one of the largest law firms in the world. We have over 4,000 lawyers, as was mentioned, over 70 offices in 40 countries. We're the largest law firm in the United States. One of my jobs is to go around the world, as Mark intimated, and to provide training to our lawyers. My aim is to see that all our lawyers, whether they're in Paris, whether they're in Hong Kong, whether they're in Egypt, whether they're in Mauritius, have a level of training and standardization that's equal, so that our lawyers in Mauritius can go work in Paris, they can go work in Amsterdam, they can go work in Beijing. And I came here specifically in order to train our lawyers on the new loan market agreements and developments in relation to them, because we are very interested in using Mauritius to move into Africa, as the Deputy Governor said, as Mark intimated, and we are getting our lawyers up to speed with the most recent developments, and that they can use the best documentation going forward in this enterprise. So I am here to also meet our clients and to talk about recent developments, the key developments in the international legal and banking market. Now there are 6 topics that we cover. Now I provide this in Africa, Mauritius, Europe, Asia, the Middle East and continental Europe. It's not directly, there are implications for Mauritius. I'm not a Mauritian lawyer, I cannot comment on Mauritian law, but it just happens to be the case that the top 3 directly impact upon your banking and legal practice in this country. Number 4 is like a missile heading your way and will hit you in about 2016. The bottom 2, the 5th one, and the 6th one, we will try and get you agency provisions if you're a bank that's of interest to you and you're able to protect you. But I will now start. It's a lot of ground to cover. You're professional people, you don't have time, so I'm going to move very fast. The Deputy Governor spoke about FATCA, and I want to summarize for you the recent developments in FATCA and what this means for your practice here in Mauritius. Now, FATCA stands for the US Foreign Account Tax and Compliance Act. The United States is the most powerful country in the world, whether we like it or not, and they can pass rules which have extraterritorial effect. That is, they pass rules that for domestic reasons in the United States, certain senators and congressmen sat around in America a few years ago and said there are American taxpayers, American green card holders, American citizens, foreign citizens who owe the American IRS money, and they're hiding it in overseas banks, potentially including in Mauritius, and we want to get at those banks. And so they passed legislation that impacts upon you here in Mauritius, us in the United Kingdom, and it has enormous global extraterritorial reach. It is a third-party reporting regime that impacts upon non-US foreign financial institutions, and the stick they hold over your head is a potential 30% withholding tax, a significant amount on US source income. What does that mean? Here is the case. I've just used one example, a Nigerian bank, but it could be a South African bank, it could be a Mauritian bank. Americans come around, they say, you, Nigerian bank, Bank of Nigeria, Bank of Lagos, you have an account holder that owes us tax. Give us that information. Now, the Nigerian bank or the Mauritian bank, whatever the target here, has two options. They can say, I comply. I will give you that confidential information. And they can do that. Now, I cannot comment on Mauritian law, but I presume there are confidentiality, data protection, etc., pieces of legislation. If you don't give my information to some American tax authority, you are in breach of confidential information, my personal data, and I potentially will sue you. Okay? So that's the risk you run. If the bank, the Nigerian bank, or South African or Mauritian bank says, no, I will not comply with the American request for confidential information about my account holders, then the United States tax authorities go scrummaging around. They find that this Nigerian bank, this target bank, has made a $2 billion loan, in our example, to a US company, and that company pays interest and principal. The American IRS will then potentially impose a 30% withholding tax on that US source income onto the Nigerian bank until that Nigerian bank complies. And that's why the Mauritian government went and signed FATCA to avoid that situation. That US company has got nothing to do with the individuals that are being targeted by the Americans who believe that they are account holders hiding in that Nigerian bank. There's no connection. This is just a US source income. And this is the stick that they hold on to the target bank until the target bank coughs up that information. And that is what FATCA is. And they can do it to Mauritian banks, they can do it to Chinese banks, they can do it to English banks, they can do it to Canadian banks, they can do it to anybody. Now, the first question you have to ask yourself, who does this apply to? It doesn't apply to American banks. It only applies to foreign financial institutions. Am I a foreign financial institution? The foreign financial institution in American legislation is drafted very, very, very widely. So there are many people in this room that I've seen from the guest list who will fall under the heading foreign financial institution. Do you accept deposits in a banking or similar business? If you do, you are a foreign financial institution and potentially subject to FATCA. Do you hold financial assets on account of others? You're a target of FATCA. Are you an insurance company? Are you engaged primarily in the business of investing in financial assets? It's a very broad definition. You will potentially be subject to a FATCA withholding if you do fall within that definition and you do not comply with the request to provide information on your account holders. There are some exemptions, right? If you are a pension fund, primarily a pension fund. If you are a state organization, such as an international government, international organization, central bank, you will get out of that. But short of that, you will fall within FATCA definition. Now, skipping that slide, here are some dates. Just let me say aside that my slides are quite detailed for the last four topics, but these are relevant dates with FATCA. The only one I want to tell you about, only two I want to tell you about are the bottom two. 30th of June 2014. FATCA, stage 1 of FATCA, this situation started on the 1st of July 2014. FATCA is not retrospective and only applies to new deals. so that if your financial institution entered into a deal with an American company or a company that has American source payments, it only applies after the 1st of July 2014. Every deal before that, Americans cannot get those companies to withhold if you don't comply with a request on your clients. It's only from the 1st of July 2014 for new deals. Don't worry about your old deals. With one exception, and that's the last side, grandfathering. What do we mean by grandfathering? We mean all old deals before the 1st of July 2014 are grandfathered. They are old. You don't have to worry about factor for your old deals. However, there's this material amendments. So, 1st of January 2013, you lend this company $10 million. Is that potentially subject to factor? No, because it precedes 1st of July 2014. The deal is grandfathered, it is old. However, that client comes to you last month and says, you lent me $10 million to purchase a property in Port Louis. Advance me another $2 million because I need to buy an extra piece of equipment. So you amend and restate the loan agreement. Any material amendment to an old grandfather deal brings that deal potentially within factor. So an old deal, you've got no problem, but an old deal that is materially amended after 30th of July 2014 brings you within the scope of factor. What does material amendment mean? We don't know. So our advice in London is any change to your deals, unless it's a typo or something like that, is potentially a material amendment and brings you within factor. Now, as the Deputy Governor said, when that situation arose, this was passed for domestic reasons in the United States. There was no concern amongst the American authorities for your Mauritian confidentiality issues or bank confidentialities. That's foreign stuff. They're not interested in that. Nor were they interested in us in the UK. And nor were they particularly interested in the costs. I mean, the costs of complying, as the Deputy Governor indicated, are not insignificant, potentially. No one considered that. And the banks were really, really unhappy. So what happened is that factor has been kicked upstairs. There's been a massive shift in approach. And now the thrust is to deal by factor by way of government-to-government reporting. And so instead of your financial institutions dealing directly with the IRS, you deal with your local Mauritian tax authorities who deal with the Americans. If a request comes to you to COFA to provide information on your clients. The relevant page is that page over there, and there are various IGAs that have been intergovernmental agreements that have been signed. Mauritius, as was stated, was the first African country to enter into an intergovernmental agreement with the United States, meaning that it's to be dealt with on an intergovernmental basis. Model 1s, or what you signed, the two Model 1s, Model 1A and Model 1B. The Model 1A is where the Mauritian authorities, if they believe that there are people in the United States that owe the Mauritian government tax, can go and make a request via the IRS for that kind of information. That, of course, makes it more politically palatable. A Model 1B is a one-way request only. Only the Americans can request it. Model 2s are where there is no government intermediary, where the banks deal directly with the IRS.